Good morning, everyone. My name is John Rickzel Macalos, and I am here to report about the Law on Partnership and Corporation, Chapter 4 of the Philippine Tourism Law. Here is our learning objectives. Differentiate the various kinds of partnerships and corporations and responsibilities of partners and incorporators. Identify the requirements in the information and dissolution of partnerships and corporations. Our topic outline discusses about partnership, corporation, and articles. The law. The tourism industry must meet legal requirements to operate. A strong business foundation is key, with partnerships and corporations being ideal structures. Partnerships follow the Civil Code of the Philippines, while corporations are governed by Batas Pambansa BLG 68 under Article 1767. Partnership involves shared resources and profit. A partnership is an association of two or more individuals who co-own a business for profit. It requires mutual trust, meaning no one can join without the consent of all partners. This describes the two key principles of partnership in a business or legal terms. Contribution. Each partner must provide something of value, such as money, assets, or services, to partnership's common fund. This contribution helps finance or support the partnership's operation. Profit sharing. All partners must agree to share both profits and losses according to the terms of the partnership agreement. This means that if the business earns a profit, it is distributed among the partners based on their agreed upon shares, and if there are losses, the partners also bear responsibilities. In short, these principles ensure that all partners contribute to business and share in its financial outcomes. These are the advantages and disadvantages of a partnership as a business structure. Here's what each point means. Advantages. Easy to establish. A partnership is relatively simple and inexpensive to set up compared to corporation, as it usually requires only a partnership agreement. Growth potential. With multiple partners contributing skills, money, and effort, the business has a better chance to grow and expand. Less bureaucracy. Partnerships face fewer legal and regulatory requirements than corporations, making management and decision making more flexible. Disadvantages. Instability. The business may be unstable because it depends on the partners. If one partner leaves or there is a dispute, the partnership may dissolve. Difficulty in raising large capital. Unlike corporations, partnerships cannot issue stock, making it harder to raise a large amounts of money for expansion. Partners are liable for each other's action. In general partnership, each partner is personally responsible for business debts and the actions of other partners, which can be risky, hard to dissolve. Ending a partnership can be complicated, especially if there is no clear agreement on how to divide assets and responsibilities. Here are the types of partnership. First is the by subject matter. There are two kinds, the universal partnership and the particular partnership. Universal partnership, all property is contributed to a common fund. Particular partnership is limited to specific assets or venture. Second is liability. There are also two kinds, general partnership and limited partnership. General partnership partners have unlimited liability, while limited partnerships some partners have liability limited to their capital contribution. Third is the duration. It only has fixed term partnership, which means exists for a set period or until a specific task is completed. Forms of partnerships can exist informally unless required by agreement, includes real estate requiring public documentation, and limited partnership requiring SEC registration. These are the obligation and rights of partners in a partnership. Here's what each point means. Monetary or contributions. Every partner must contribute money, property, or other valuable assets to the partnerships as agreed upon the partnership contract. Second is the industrial partner's obligations. An industrial partner contributes labor, skills, or expertise instead of money or property. Their obligation is to actively participate in the business operations. Third is the capitalist partner's obligations. A capitalist partner contributes capital, may it be money or property, to the business. They are responsible for financing the partnership and usually share in profits and losses. Fourth is the partnership's duty to partners. The partnership, as a business entity, must treat all partners fairly, follow the terms of the business partnership agreement, and provide necessary financial and operational information. Fifth, profit and loss sharing. Partners must share in the business's profit and losses according to the agreed upon terms. This means that if the business earns money, the partners also benefit. But if it loses money, they also share the same loss. Sixth, partners' property right. Partners have right over partnership property, but this property belongs to the partnership as a whole, not to individual partners. Partners cannot use it for personal purposes unless agreed upon. Liability to third parties. Partners are responsible for the debts and obligations of the business. In general partnership, all partners can be held personally liable for business debts. And finally, limited partners liability. A limited partner's liability is restricted to the amount of money they invested in the business. Unlike general partners, limited partners are not personally responsible for their partnership's debts beyond their investment. Discussion of winding up partnership. Partnership dissolution. Dissolution without breach. The partnership ends legally and fairly without any wrongdoing. This can happen in the following ways. Term or project completion. If partnership was created for a specific time or project, it automatically ends when the time is up for the project is finished. A partner lives in a good faith. If there is no set duration for the partnership, a partner can leave at any time without causing a legal issue. Mutual agreement. All partners decide together to dissolve the partnership. Expulsion per agreement. A partner is re- a partner is removed based on rules stated in the partnership agreement such as misconduct or failure to meet obligations. Second is the dissolution without breach. The partnership ends because a partner violates an agreement or acts unfairly, causing harm to the business or partners. A partner wrongfully forces dissolution. If a partner tries to dissolve the business unfairly, like leaving suddenly despite a contract or sabotaging the business, it is considered a breach of contract and the partners may take legal actions. Third is legal or practical issues. The partnership must dissolve due to external circumstances that make it impossible or unlawful to continue. Business becomes illegal if the law changes and the business can no longer operate legally, like selling a product that later becomes banned. The partnership must dissolve. Contribution perishes before delivery, unless already owned. If a partner promised to contribute something like equipment, land, or money, but it is lost or destroyed before being transferred, the partner may dissolve unless the partner already owned and committed it. Partner's death, partner's death, dissolvency or civil interdiction. If a partner dies, goes bankrupt, or is legally declared incapable, like through a court ruling due to mental incapacity, the partnership may dissolve unless there are provisions to continue. Court orders dissolution. If a judge determines the partnership cannot function properly, they can be ordered to be dissolved. Fourth is the court order dissolution. A court can force a partnership to dissolve if certain conditions are met, such as partner is insane or incapable. If a partner is declared mentally unfit or legally incompetent, the court may dissolve the partnership. Partners' misconduct harms to the business. If a partner engages in fraud, illegal activities, or unethical behavior that damages the partnership, a court may step in. Persistent agreement violations. If a partner repeatedly breaks the terms of the partnership agreement, legal action can lead to dissolution. Business can only operate at a loss. If the business is no longer financially viable and continues to lose money, the court may order dissolution. Other equitable reasons. Any other serious reasons that makes it unfair or impossible to continue the partnership, like irreconcilable disputes between partners. Fifth, by purchaser of a partner's interest. A partnership may dissolve if someone buys out a partner's share, depending on the type of agreement. After a fixed term, if the partner was formed for a set period, it can dissolve when the period ends, especially if the partner's interest is sold. If the partnership was at will, in a partnership without a fixed term, any partner can leave at any time. If a partner sells their interest, it may lead to dissolution unless the remaining partners agree to continue. These are the advantages of a corporate organization: strong separate juridical personality, limited liability to investors, free transferability of units of ownership, centralized management through the board of directors, professionalism, easier to sell small amounts of stock to raise capital. These are also the advantages of a corporate organization. It only has three, which are the extensive government regulation, double taxation, and the activities are limited by charter and various laws, centralized management through the board of directors. The next slide is all about the distinction between a partnership and a corporation. We have the formation, the liability, the management, the legal existence, the number of owners, right of succession, transfer of ownership, duration, and the dissolution. Now, let's talk about the different kinds of articles. First, we have the Article 1, the subscription, insurance, and transfer of shares. Shareholders must pay for their shares as set by the board, with no interest on unpaid shares unless specified. Fully paid shares receive a certificate signed by the president and the secretary and recorded in company books. Transfers are valid only if recorded, and unpaid shares cannot be transferred. Lost or stolen certificates must be replaced per the corporation code. For Article 2, the meetings of stockholders. Stockholders hold annual meetings to elect directors and special meetings as needed. Meeting occur at the principal office or a designated location, with 2 weeks' notice. Only listed agenda items are discussed. A quorum requires a majority of outstanding stock. The chairman, president, or an elected chair presides with the secretary recording. Stockholders vote in a person or by proxy, which must be submitted in advance and is revocable. The board may close stock books or set record date up to 20 days for voting and dividends. Article 3, the Board of Directors. The Board of Directors oversees corporate affairs, including setting rules, managing assets, investing funds, handling debts, selling properties, establishing employee benefits, and delegating authority. Directors are elected annually by stockholders and serve for 1 year. Vacancies, except those due to removal or terms expiration, may be filled by the remaining directors if a quorum exists. Otherwise, stockholders elect a replacement. Board meetings are held quarterly and scheduled by the chairman, president, or a majority of directors. Article 4, Officers. The Board of Directors elect corporate officers, including the chairman, president, vice president, treasurer, and secretary. One person can hold multiple roles, except for the president, treasurer, or the secretary. The chairman presides over meetings. The president manages daily operation and represents the company. The vice presidents assist as needed. The secretary handles records and compliance, and the treasurer manages finances. Officers serve 1 year terms but can be removed for cause. With vacancies filled by the board, officers' compensation is set by the board. With input from the president, and directors may also hold paid officer positions. Article 5, Office. The principal office of the corporation shall be located at the place stated in the Article 3 of the Articles of Incorporation. The corporation may have such other branch offices, either within or outside the Philippines, as the board of directors may designate or a business of corporation may from time to time require. And that concludes my report. Thank you so much for listening.